Okay.
This meeting of the Code Enforcement Board of the City of Cape Canaveral is now called to order, and thank you for your patience. Okay. One of the first things we do is call a roll. Shall we start with that, Ms. Ginger?
Ms. Russell.
Here.
Mr. Godfrey, not here. Mr. Hale.
Here.
Mr. Hartley.
Here.
Ms. Collins. Here. Ms. Stone. Here.
So with the exception of Walter, we're all here. And I'm sorry, Mr. Clooney, Chris. All righty, and we have as our secretary tonight, I'm sorry, our attorney tonight. The secretary's there, the attorney's there. And tell me your name again.
Deborah Nutcher.
Thank you. I spent several hours today watching the video of last night's city council meeting, and the thing I learned was if you're not talking in this mic, it's not going on the tape.
That is correct.
And so if you're going to speak, respond, say yes, no, let's go home, turn that mic towards your mouth, because there were great parts of it that I missed. Okay. We need to determine our next meeting date, which will be in June. Traditionally, we are the third Thursday following the third Tuesday. And I don't see a calendar in front of me.
No,
Oh, down in the hole, there it was. Jimmy found it. So if we use our usual formula, we will be meeting on the 20th of June, is that correct?
Correct.
Okay, so put that on your calendar. If you already know you're not going to be here then, let Ginger know. And if you find out it between now and the 20th, let Ginger know so we can make sure we have a quorum.
I will not be here.
Okay, thank you.
That's one. Okay, anybody else know now? If you're going to be giving testimony before this board tonight for any matter that we will be discussing that's on the agenda, please stand and be sworn in by our city attorney.
Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Okay, thank you. We have before us the minutes of the meeting from April the 18th. Are there any corrections or additions to those minutes as published? Hearing none, can we have a motion to accept them as published?
I move we accept them.
Second.
Motion and a second. Is there any further discussion? Hearing none, call the vote on the minutes.
Ms. Russell.
4.
Mr. Hale.
4.
Mr. Hartley.
4.
Ms. Collins. 4. Ms. Stone.
4.
And we thank Mr. Hartley for a well-run meeting last month.
And chairperson is not permitted to be absent in the future.
Okay. I think that was a compliment.
It was, thank you.
Or a threat, I'm not sure which. Okay, on our agenda tonight, our first case is number 18253, Patrick Campbell. This is the case number, what do we do to get this thing to scroll? There we go. This legal address is Cape Canaveral Beach Gardens, Unit 2, Lot 4, Block 7, street address 307 Surf Drive, Cape Canaveral, Florida, 32920. This is a violation for property maintenance, and this is your case, Mr. Robinson? Yes, ma'am. Go for it.
Okay, the notice of violation sent out 9/24/2018, return receipt 9/26/2018 to Patrick and Jane Campbell, the property owners. Notice of hearing April 15th, 2019, return receipt April 18th, 2019. This is property that we're here to discuss on Surf Drive. 9/21/18, during patrol, the city staff observed a fence falling down on the east side of the property. Further inspection revealed no numbers on the house identifying the address. The siding on the east side of the house.
Excuse me, Chris, please speak into the mic more. Thank you.
I'll start over.
You'll have to shorten yourself about 6 inches.
9/21/18, during patrol. Is it on? Can you hear me? There we go.
Yes, I
Now I
can.
can.
Thank you very much.
All right, 9/21/18, during a patrol of the city, staff observed a fence falling down on the east side of the property. Further inspection revealed no numbers on the house identifying the address. The siding on the east side of the house is gone. Drip edges on the northwest side and along the front north side are gone. The air conditioning condenser and pool equipment are not shielded from public view, and there is no permit for the screen enclosure around the pool. 9/24/18, notice of violation was sent to the property owner. 10/5/18, the permit for the pool screen enclosure was reopened. 10/19/18, the permit for the siding was reopened. 10/22/18, follow-up site visit revealed the address numbers, drip edge, and fence are now in compliance. The shielding of mechanical equipment and the siding are all still in violation. 4/15/19, notice of hearing was sent to the property owner. 5/8/19, a site visit revealed the mechanical equipment is now shielded from view and is in compliance. The siding is actively being installed. 5/23/19, the siding appears to be complete. All that is required is a final inspection and the property will be in compliance with the notice of violation. These are the photographs I took on September 24th. As you can see right there, the drip edge is missing on the front portion there to the left of the house. This is the fence. If you look towards the left by that palm tree over there, you can see that the fence is falling over. If you also look towards the middle, more towards the right of the house itself, you can see drip edge missing, and then below that, there's no siding on the house. Another angle of the fence and no siding on the house. Another angle. Yet again, another angle. This is the front showing that there is no address numbers on the house.
But they are on the mailbox. Does it have to
they
be
were
in
two
both locations?
No, they're required to be at least 3 inches tall, and the ones in the
Okay.
mailbox.
So it's size, not location?
Yes, ma'am. Closer shot of the drip edge missing and the unshielded mechanical equipment. Again.
One question.
Yes, ma'am.
Is the mechanical equipment, if it's not visible from the street,
Yes, it has to be shielded, whether through plants or a fence, something so that you cannot see it from the right-of-way, the public right-of-way.
from the right-of-way?
Yes, ma'am.
Okay, not the street view?
Yeah, and it says when practical. In some cases, you can't practically shield mechanical equipment. For instance, in a parking lot, if it's all concrete,
Sure.
it's not practical to shield it.
Okay.
So, and I will now turn it over to the property representative.
So we gotta be sure I can operate the system. There we go. So first, I want to thank Mr. Robinson for that excellent summary. Everything that he said was correct. But I'd like to take this opportunity to speak to the board, speak to my community, and explain how I got to where I am with this property.
In any way, shape, or form, are you going to be dealing with the property that is to your west of your house?
As an explanation of why my property is the way it is, yes. And the effect of part of that property on why mine is the way it is.
Can you do that in 2 minutes or less?
I will attempt to speak as fast as I can. That will entail reading from my presentation, but I'll get through it.
Because technically, we only can hear things related to are you 307, correct?
I'm 307, the
Right.
property next to me is 305. However, the situation at 305 is an explanation why my property got the way it is.
I can understand how that created all kinds of havoc with dealing with your property, but as I said, we are not here to hear anything that relates to that case other than how you are doing with your house, and it looks like it's ready to be signed off.
Not quite, and I kind of don't agree with part of the violation.
The violation for your property
On my
that you're
property.
sided with.
That's correct.
Okay, well, can you speak directly to that?
Yes. First, I'd like to thank the board for your dedicated support to our community. I'm very much aware that city management is attempting to go to a special magistrate system. I am opposed to that, as are others in our community. But I do thank you for your support. My opening page is a recognition that Mr. Robinson gave me the opportunity to avoid coming to this hearing. I respectfully declined not coming to the hearing because I wanted to speak to the board. So there's a better picture of the mess that Mr. Robinson found at my property. That's the entire east side of my house, and you can see that there is no siding on the house. A number of reasons for that. One obvious reason that happened to a lot of us is storm. But that wasn't all. I was having siding put on the house. The contractor that was doing it did not order enough material. Not an uncommon story, but that and a few other problems that I was having with the contractor, I asked him to leave the property, and I took on taking care of it for myself. But what I'm really here is to explain why a resident, been here for 40 years, built that house, my wife and I, drove every nail in it, worked 9 months after work during the weekend, raised 2 fantastic, successful children in that house. Never been in front of this board before, never had a problem with code enforcement in the 40 years that I've lived in Cape Canaveral. I was offered the opportunity to not come to the board. So why would I want to be here? Why would I want this meeting to happen? I'm not here because of the violations. The violation that I'm here about is the mechanical equipment. The rest of them, as Mr. Robinson explained, I believe I've done a pretty good job of getting it taken care of. It is not complete. I had a health issue here a few months ago to where I was down for 2 complete months, so I didn't get everything done that I needed to done, but almost all of it is complete. The screening of the mechanical equipment, as Mr. Robinson said, is complete, but I want you to hold that thought. I'm going to come back to it. I'm here because I gave up. For the past 20 years, I've lived next to a blighted property. The city was not effective in meeting the promise of compliant inherent in law and our ordinances. Words, dates, commitments meant nothing. I was patient for years, and then I started complaining. This case is about retribution for my public dissatisfaction.
Wait. We're not going through all this. We've seen all this. This is the board that sat through it as long as you did, sir. At least most of us sat through it as long as you did. So
Understand.
get to the point.
I am at the point. I heard the code enforcement outreach session in which code enforcement declared that the primary purpose of code enforcement is voluntary compliance. The Code Enforcement 101 outreach session says the process is contact the owner and attempt to gain voluntary compliance. That is not how I was treated. I'd like to play a video for you that has to do with the violation on my house that I do not agree with,
On your home?
on my home. Can we get the speakers up somehow on this?
They're up as far as they can go. Brian, can the speakers go up on your laptop?
Yeah, it looks like it's way down.
There you go.
Hope this doesn't blast anybody out here.
What we're hearing is coming from there, but not up here.
I-
You can summarize what.
Yes. Can you summarize what it
Okay, this
says?
video is from 2/21/19. It's a video clip. It's a video clip from a code enforcement hearing. The discussion that's being held at that point is Mr. Robinson explaining that there's no ambiguity in the requirement to screen any air conditioning unit that can be seen from the public right away. This video is Mr. Robinson explaining the interactive map that you were provided at that same meeting as a piece of evidence as the ability to see what code enforcement violations are being taken care of in the city? Okay. The absence of equipment screenings all over the city, check it for yourself, your street, your neighbors, anywhere on the ground, on roofs. Certificates of occupancy are given to properties with this violation present. Enforcement's arbitrary and, at least in my case, punitive in a pattern of targeted enforcement. Additional aspect of city management influence at the expense of the citizens is the code enforcement case map that was provided to you as an ability for a citizen to see where their code violations are. And now I find that for me and others that have been accused of the violation of not screening your air conditioner, it may not be a violation at all.
Okay, so your point's made.
Okay.
Now let's go to the end of this point.
Mr. Dickey provided me an email inadvertently, and I let him know it was an inadvertent email. It should not have come to me. It should have went to a place called City Watch. But in there, Mr. Dickey was explaining why the violations that were cited for 8150, 230 Columbia, and 220 were not a violation. They were not a violation because the buildings were built prior to the enactment of the ordinance 10-1988. My home was built in 1984. I respectfully ask the board to consider and order that the equipment screening violation as written in my case be rescinded. I be made whole for the money spent to comply with the non-violation. I would like a complete review of any similar action taken on any other citizens, companies, or corporations of Cape Canaveral, and where the ordinance was applied in error, they be made whole. The city to formally publicize this ordinance clarification to all media generally used by the city for communication to the city of Cape Canaveral. A complete review of any pending code enforcement actions with section 3498 as alleged violation to ensure applicability of the ordinance to the alleged violation. A review of the certificate of occupancy process to ensure COs are not issued with violations of 3498 evident. And because of my recent injury, I asked to be granted an additional 90 days to complete the few pieces of siding and fascia that I have to take care of the rest of my siding.
Thank you, that's very specific. In your request just there, would you put that back up on the screen? You're asking for an additional 90 days to complete something that you don't need to do, according to your definition?
I'm sorry, Madam Chair. I do have some other things to do. While Mr. Robinson gave me credit for everything that I did, I appreciate that. There were a few things that still remain to be done before I can call for the final. I've got a piece of fascia boards, not drip edge, it's fascia boards. The contractor that I had custom fascia made, so now I have to get custom fascia made to match what I have. Can't just get it at Home Depot, and lo and behold, everybody's busy.
Yes, they are. Well, we thank you for your presentation. We appreciate your cooperation. As to the city's response for what you are asking, to whom does that go? Right here? Does it stop here with us? Are we satisfied when we let Mr. Campbell have his day in court and say what he needed to say to clear himself and to clarify what everybody else is here to hear? I'm pleased, I was most pleased with the compliments you've paid this board. You've certainly gone out of your way, considering what you went through because of the extreme amount of time it took to satisfy the property next to you. I hope you're enjoying that view.
Not yet. It's nice. I mean, the house is gone, the mold is gone, the smell is gone, the mosquitoes are gone. I'm looking forward to a house being there.
I'm sure you are, and so are we. We would rather have the property on the city as an improved piece rather than a derelict piece. But we thank you for coming tonight.
So where do we go from here? Is my extension granted? What do we do now?
We'll entertain a motion to extend.
I asked staff for.
What's your recommendation, Chris?
I don't get that in a minute.
I'd just like to touch on something that he brought up about the air conditioner being screened. He is correct in everything he said, but in one part. He initially had his air conditioner screened with a 6-foot privacy fence. So once it became unscreened, that's when he became in violation. So when the fence came down, now it changes everything. If he had always had that up prior to the enactment of that ordinance, and it had always been that way, and never put a fence up, then he's correct, he would not be in violation. But since he had a fence up and since it was screened, and then he took it down, it then became in violation. So I just wanted to.
That was not
show-
clear to me at all. Thank you for explaining it to us. And what's the city's recommendation?
I'd love to tell you.
Could I respond? Could I respond real quick?
Let's hear his recommendation, and we'll hear your question. That's not what he wants.
You don't want to use this?
No, because.
Ah, here we go.
Okay.
Oh, now
Whoops.
you gotta go back.
Back one.
You get it?
Yep, you're going forward.
There you go.
Okay. Based on the testimony and evidence submitted at this hearing, staff respectfully requests the Code Enforcement Board find the respondents in violation of Florida Building Code Section 110, Inspection, subsection 110.1, General. Give the respondents until June 12th, 2019 to come into compliance or a fine be imposed in the amount of $75 for the first day and $50 every day thereafter until compliance is confirmed by the Code Enforcement Officer and all costs associated with the enforcement of the violation of this be imposed. Of course, this is just a recommendation. In light of what Mr. Campbell just said, the city would be open to continually working with him.
Okay. Thank you. Mr. Campbell, you still wish to speak?
Thank you, Mr. Robinson, for introducing the absence of my fence. My fence went down when my neighbor's fence blew over and pulled it with him. Thank you.
Thank you. Okay, I think we've heard everything that needs to be presented here. Is there a motion from a member of the board as to what you wish to do with this case? Or question?
What I've heard is we only need one inspection. Is that correct, Chris? Or
The
he has some
inspection of the vinyl siding, that is correct.
final- Okay. Yeah.
And Mr. Robinson hadn't been involved in this, and it's gone on a long time. Part of that's my fault. The inspections for siding and doors and windows, I just want to make that clear. I also want to make it clear that the original permit that I pulled on the house to put the doors and windows in, at the time I did it, there was no requirement for a permit for siding. When I re-pulled it, thanks to Mr. German, I re-pulled it and we included the siding in the final inspection, but it does include doors and windows.
Well, let me ask this for clarification. What additional work, if any, needs to be completed before the final inspection?
I have about 15 feet of soffit that needs to be retained with the fascia board. I've got a couple of areas of siding that were done by the contractor. They're going to have to be removed around my pool equipment and replaced because it's done incorrectly and buckled up. And on one corner, I've got a fascia and a corner board to take care of.
And is your contractor giving you a time frame?
I do not have a contractor, it's me.
You, and what is your estimated time of completion?
If I could get another 90 days, that would be great. If I can't, it'll be as good as you'll give it to me.
Do you have the fascia that you needed to order on order?
Yes, I do, through a place on Gus Hip Boulevard in Rockledge where I've had some other work done.
Okay,
But they're looking at perhaps 6 weeks to get around to my 3 pieces of fascia board.
don't hold your breath.
I know.
Okay,
It took 4 months to get more siding.
anybody else have a question or comment? The chair will entertain a motion.
I move that we accept staff recommendation by striking June 12th, 2019, and inserting September the 12th, 2019.
I'll second that.
We have a motion and a second. Is there any discussion? Hearing none, call the vote.
Ms. Russell?
4.
Mr. Hale?
4.
Mr. Hartley?
4.
Ms. Collins? 4. Ms. Stone?
4. There you go. Thank you. Thank you. We appreciate your great display of patience.
I appreciate all of you. I hope the special magistrate doesn't happen.
Thank you, Mr. Campbell. Moving on, we're looking at case number 18, what number? 256? Oceanside Treasure LLC, care of Wells Jeffrey R.A., street address 209 Chandler Street, Cape Canaveral. I believe it's unit number 219, is that correct? And we will hear Mr. Robinson again.
One quick thing, little housekeeping. If you're going to give testimony, if you could please print your name
Oh.
and sign in on this sheet, please. Thank you.
Thank you. Okay, Chris.
Okay, this is Oceanside Treasures LLC. The address is 209 Chandler Street. It's going to be Unit 219. Legal is on the board, parcel ID is on the board. The violation is for work without a permit, Florida Building Code Section 105.1. Notification, 10/4/2018. Notice violation was sent out. Return receipt, 10/9/2018. Notice of hearing, 4/15/2019. Return receipt, 4/16/2019. This is the property in question. This is off of Canaveral Beach Boulevard, or Canaveral Boulevard.
Which unit?
If you look, there's 9 units there. It's going to be on the very right-hand side, the second one on the top. It's the second one in. So you see the one on the very end alone by itself
Right.
on the right, the one right
There's-
next to it.
2 white objects on the roof?
Yes.
Okay.
Yes.
So we're talking about the same place. Go.
10/3/18. Staff was addressing a violation of an abandoned vehicle when loud banging like construction work was heard coming from Unit 219 at 209 Chandler Street. Staff knocked on the door and a Wells Brothers employee answered. The employee was asked what was going on, and he turned and pointed to the floor and said he is removing the floor because it was damaged. Staff asked if we could look in at the rest of what he was doing. He said he wasn't really supposed to let anyone come in. Staff explained the need to see exactly what was being done to determine if a permit was required. He stated whatever, moved to the side, indicating entrance was okay. Upon entering the unit, the entire subfloor had been removed. Stringers and insulation that was under it were visible. Photos were taken of the demolished floor, and the property was posted with a stop work order. Citation number 0139 was issued and later voided out.
Question real quick.
Yes.
Is that a second-story unit?
Yes, ma'am, it is.
Okay.
On February 12, 2019, staff conducted a follow-up site visit and discovered repairs were again being performed to the subfloor and the stop work order had been removed. Staff made contact with the individual working in the unit, informed him a stop work order had been posted by order of the building official due to the type of work being accomplished requiring a permit, and he was not allowed to do any work in the unit without a permit. He stated he did not need a permit and contacted the office. Jeanette LeBoy made contact with staff and stated she emailed the permit tech and asked, quote, "Do you need a permit for repairing subfloors? We don't need to replace it, just need to repair some areas that need it." The permit tech responded with, "No permit needed for flooring." The building official is the only individual who can determine whether a permit is or is not required. The building official is also the only individual who is authorized to remove a stop work order. A second stop work order was posted on that day. This was a photograph of the missing subfloor on the initial response on October 3rd. Another photo. Here's another photo. The next photo is a photograph on my follow-up visit on February 12th, where they were again doing the work. And you can see now there's some 2x4s there that I was told were going to be sistered up against the joists in there to help support the wall and some damage that was going on. Now, I want to kind of go back to 105.1 that requires a permit. I have the building official here that can answer any questions that pertain to when a permit is required and when not, so that you can ask him anything. But 105.1 basically states that, any demolition, which there's clear demolition, or any repairs that are being done require a permit. Now, if it's going to be a minor repair, which the building official who will attest to that has determined this was not a minor repair, this was a major replacement of parts. Even if it was a minor repair, it would still require contacting the building official to get his permission to do the work without a permit. And in this case, if they had called him, they would have discovered that this is not a minor repair, this is in fact a major construction, and it does require a permit.
Were there people residing under Unit
Yes, there
19 during
was.
this?
Yes, there was. Which was one of the concerns I had, because if you look at this, there's nothing in between them. I mean, if he would have slipped and fell, if he'd have dropped, so this was a public safety concern for us. Anything could have happened. I'm not sure what those lines are. I don't know if they have gas out there. Even if it was water, anything could have happened. So that's our major concern, and this is why we require permits, particularly for something to this scope.
Thank you. And,
What would you like to see something?
no, I'm.
Oh,
I'm-
okay. I thought you said
No,
something.
I'm up to speed, I think.
Okay. Turn it over to the property representative now.
And who's speaking for the property tonight?
I am.
Would you step to the mic and tell us your name, please?
Yes, my name is Anne-Marie Geary. I'm here on behalf of Wells Boys Property Management, and we are the managers of the Oceanside Treasure Unit 219. I also have here tonight Miss LaBoy and AJ, who was the one of the workers who were there that day when Mr. Robinson showed up the first day. So we'll be presenting some testimony, and I'm also be discussing some issues of procedural due process and our concern with
Procedural what?
due process.
I thought you
Yes.
said deposits. And that threw me.
No, due process. And if you don't mind, I want to get my notebook out. I don't know if I'm going to mess anything up if I set it down here. Okay. I prepared a memorandum in opposition. I want to be able to submit for the record. I have several copies here if the board members would like one, or would just submit one for the record.
If you have one for everyone, we'd be delighted to have one, and we'll mark it as Exhibit A.
3, 4, I have 5.
If I could look at this real quick before we submit it, because I have a feeling this is going to be the lawsuit that they have, and I'm going to have to object. I don't think it applies to this matter.
Can I take a
If
look
I
at it?
may speak, I mean,
I take a
let
look at
him
it?
speak, yes.
Just let me take a look. Thanks.
And I will be addressing all the facts today, including the timing of the lawsuit, the timing of the rescission of the citation that was issued directly to Mr. Wells, and the timing of the notice for the hearing today.
Is this lawsuit that you're referencing deals specifically with this unit?
Yes, it does. And I also have our own photographs that were taken and a copy of the email that Ms. LaBoy sent to the building department. So if I can just go ahead and present those to
No, we will wait for our attorney's opinion.
Okay.
Well, I mean, I guess my concern is that there's an extreme amount of facts in here, and the purpose of this hearing is to gather facts the proper way, not the way the attorney has couched the facts.
Well, we're here today. The notice says we're able to present. You're entitled to testify and present evidence and witnesses in defense
Right.
at the hearing.
You're
That's
not
what
a-
we're doing.
You're not a witness, though, are you?
I am presenting 2 witnesses. Yes, sir.
But you're not the witness, right?
I'm here to testify on behalf of my client.
You are testifying?
Well, to defend my client, yes,
You're making argument,
of course.
but you're not testifying.
I'm here to present
I don't
evidence.
have a problem with them making their arguments. They're making arguments that the notice of violation didn't provide fair notice of the charges. They have a right to make that argument.
But we're talking about something that dated from 2018, correct?
Right. Right. If they want to make arguments, but, I mean, really, we're here to engage in the facts. If they want to make arguments about the notice didn't give them notice of what they violated, that's fine. The facts should come from the witnesses, not from the attorney. You certainly cannot make a determination of constitutional issues, but you can consider the argument that the notice was defective in some way.
I mean, obviously, this isn't a trial, but the facts of evidence aren't what apply here. And also, I mean, if we disagree with the board's decision, we're trying to lay a foundation and a record so we can take it to the circuit
Well, you're
court.
aware that the board can't make decisions on constitutional matters.
I'm not
right?
asking them to make a decision on constitutional matters, but if you're going to deny us the right to have our opportunity to be heard today, then that is a violation of due process.
I didn't think I said any such thing.
You've been arguing that. I'm sorry.
Oh, wait, it's going both ways. We're here to decide whether or not Unit 219 at 209, is it Chandler?
Yes, Chairperson.
And was in violation, and have those violations been corrected?
Well, we argue we're not in violation and a permit wasn't even required.
We're past that point. We all saw the pictures. We know what we're talking about, and you know what we're talking about.
Well,
Now, if you'd like to have someone from one of your two witnesses come up and testify as to what occurred and what they saw, we'd be delighted to hear it. But we're not going to spend this evening arguing back and forth as to who shot John.
So you're not
And
going to
that's it.
allow me to make my presentation?
Is it based only on the lawsuit that you're considering?
No, it's not based, our lawsuit is based on the notice of violation.
We're not interested in hearing that. We're here
And-
tonight to hear the case.
Okay, so I'm going to go ahead and
Well,
lay my foundation.
Madam Chair, I don't have a problem. If they want to present an argument that they did not receive adequate notice, I think that's fine for this board to determine whether there was proper notice of the violation. I think that's part of your decision-making, is that proper notice was provided.
And if we decide that, yes, they did receive proper notice, then we may go ahead and hear the case?
Yes.
Okay, go.
Okay, thank you. On September 17th, we had a resident living in Unit 219. They transferred to another unit managed by Wells Boys and Girls Property Management. Shortly thereafter, Wells Boys and Girls began preparing Unit 219 for a new resident. Due to the fact that the former resident had lived in apartment 219 for a number of years, we initiated a wide range of maintenance work, painting, including repairs to the areas of the subfloor. In this instance, we elected to replace some 4x8 sheets of particle board to repair the subfloor. We attempted to replace 7 of the 4x8 sheets of particle board with a 1/2-inch plywood to ensure that any areas where the particle board was comprised would be in need of proper repair and in the near future would be repaired correctly. On October 3rd, the city's code enforcement officer, Mr. Robinson, appeared at apartment 219. He entered the unit without permission.
Madam Chair, at this.
I know, we're not, this isn't talking notification.
You need witnesses to
I'm
establish
going to present
these.
that. These are just my facts that I'm presenting. Then I'll bring my witnesses forward to present those facts.
Your role is to make the argument, and you can present witnesses, but your role is not to present facts to the board. So Madam Chair, it's up to you, but I would ask counsel to, instead of her version of the facts, to present the witnesses to establish what the facts are.
We still need to settle the issue of the nature of her notification.
Why don't you make your arguments on the notice?
Well, I think these facts are related to the notice. And if you may, just, humor me a little. On October 9th, we received a notice of violation for the case number 2018-256. In the same envelope, there's a construction contractor citation number 0139 issued in the name of Jeffrey W. Wells. The citation was not filled out. None of the violations on there were indicated. Later on, the city actually rescinded that. In that notice of violation, Mr. Robinson represented on October 3rd, while addressing separate violations, staff discovered construction taking place in a unit. Further investigation revealed the entire subfloor of a second floor unit was being removed without the required permit. A stop work order was posted in effect until compliance is met. I'm going to bring up AJ. Can you please come up? And he's going to address whether or not it was the entire subfloor. He's representing in the notice that the entire subfloor was being. Can you come over here?
And state your name, please.
Can you please state your name?
I'm sorry.
Aaron Cooner.
Aaron Cooner.
Please speak into the mic.
Step over here.
Aaron Cooner.
Okay. And who's your employer?
You need that spelled?
Wells Boys.
Oh, can you spell your last name, please, for the record?
Chris, can you look to see if the mic is off?
No, it's on.
No, it's all.
N-E-R.
Okay.
C-O-O-N-E-R.
And who's your employer?
Wells Boys.
And what's your position there?
Maintenance technician.
Okay. And what are your job duties?
I do a little bit of drywall, plumbing, a little bit of everything.
Okay. Are you familiar with Oceanside Treasure?
Yes, ma'am.
What is it? A building complex?
Yeah, it's an apartment complex.
Okay. And are you familiar with Unit 219?
Yes, ma'am.
Okay. How often do you do work at Oceanside Treasure?
Just about every day.
Okay, so you're quite familiar with the building then?
Yes, ma'am.
Okay.
What was the question?
I asked him, are you quite familiar with the building then? And he said yes. Okay. Are you familiar with the subflooring work that was being done on Unit 219?
Yes, ma'am.
Okay. And in this unit, while you're there, how many sheets or plywood are needed in general for, let me rephrase that. When you're in the unit and you look at the unit and you make it determine how many sheets of plywood would be laid down in that unit if they had to replace the entire floor, how many sheets would be there?
About 21.
Okay. And that day when you were working on the subfloor, how many sheets were being replaced?
I'm gonna say about maybe 10.
Okay, so that was a little less than half. Okay. And were you present there when Mr. Robinson arrived to Unit 219 on October 3rd?
Yes, ma'am.
Okay.
What was the question again?
Were you present there when Mr. Robinson arrived to Unit 219 on October 3rd?
Yes, ma'am.
Okay. And can you please describe what happened when Mr. Robinson arrived?
I opened a door, told him he wasn't allowed in because of insurance purposes, and he just told me to stop working and basically just walked right past me.
All right. So did you give him permission to enter unit?
No.
Okay, so I just kind of want to reiterate. So the subflooring that was being done there that day, it wasn't the entire unit that was being replaced, correct?
No, ma'am.
So it wasn't the entire unit, correct?
No, ma'am.
Okay, that's all I need.
Wait, when do
May
we
I
get
ask
a
a
chance
question?
to ask
Okay,
questions?
They want to ask you some questions.
May I ask one question? Aaron, on that day, you replaced 10 sheets. How many sheets total of plywood did you replace in this unit?
None of them have been replaced yet.
Pardon?
None of them have been replaced yet. I was told I wasn't to go back in.
Stop work order is still in effect?
So you haven't. How much subflooring or underlayment had you planned to replace?
It was a little less than half the apartment. A little bit in each bedroom, and then what you saw in the living room.
How do you get into Unit 19? Is there a stairwell?
Yes, ma'am. There's a walkway that goes to all the apartments right there in front.
And it's outside, and then you enter from the walkway into the units?
Yes, ma'am. There's a
Okay.
walkway.
And where was Mr. Robinson standing when he made those pictures we saw?
He walked right past me and went into the apartment.
Okay. Was it a one-bedroom unit?
I don't remember right now.
Okay. Anybody else have a question?
The 2x4s were gonna be used for sisters in the wall?
That wasn't me. I wasn't there on that day.
Okay.
Is that it?
Is that it? Anybody else have any further questions? Okay, I would like.
There could be more.
Okay, I would like to bring up Jeanette LeBoy. She would come to testify.
Hi,
Hi.
my name is Jeanette LeBoy. First name is Jeannette, last name Laboy.
Okay, Ms. LeBoy, can you please tell us who you're employed by?
Wells Boys and Girls Property Management.
And what is your position?
I guess generically I'm accounts payable.
Can you describe your job duties?
Yes, I handle all the permits that I pull for all the properties in Brevard County that we own. And I also deal with petty cash and I'm blanking, but mainly the permits. I deal with the permits.
So as part of your job duties, do you interact with the building department at Cape Canaveral?
Yes, ma'am.
Okay, and how often do you interact with them?
Almost on a daily basis.
And who's the primary person that you normally interact with at City of Cape Canaveral?
Karen Hutchinson is the one that normally, when I first got into this position, she's the one that's always initiated any sort of emails pertaining to any permits or any inspections that needed to happen.
And what kind of conversations did you have with Ms. Hutchinson regarding Unit 219?
I was asked by the property manager if they could continue work, so I asked her to hold on while I got a hold of Karen Hutchinson and sent an email to her that same day. I believe it was February 8th, asking her if we needed a permit for repairing subflooring, that we were not removing the whole subflooring, we were just patching parts of it. And then she emailed me back a couple days later and told me that there was no permit needed for flooring.
And we brought that email with us today. Would you like to look at that?
Yeah. Yes, ma'am.
Okay, to the board, I'm going to present to Ms. LeBoy the email. I'll have her review it. I have copies also for you. I'll have a copy for council to look at as well. Some copies.
Are you moving this into evidence?
Yes, I am.
So is this A?
This is the email. This is the email, and Ms. LeBoy is going to testify regarding that. Okay, Ms. LeBoy, can you look at the email and tell me whether you recognize the email?
Yes, I recognize the email.
Okay, and can you take that and look at it? And what's the date of? Is it just one email or is it an email chain?
It's an email chain between me and Karen Hutchinson.
And what date did that begin in time?
The first email was initiated by me on February 8th.
At what time?
I'm sorry, 2:10 in the afternoon.
Okay, and what did you ask her? Can you just kind of repeat what it states in the email?
Yes, ma'am. I wrote, Karen, do you need a permit for repairing subfloors? We don't need to replace it, just repair some areas that need it. Thank you.
And what was her reply?
She replied back to me on Monday, February 11th at 9:04 a.m. And she just simply wrote, no permit needed for flooring. Thank you.
Okay, and can you please talk about kind of what happened and after that regarding going back to the building and there was maybe some work that was attempted to be started?
Yes. As soon as I got that email from Karen that morning, I emailed the property manager letting her know that from the reply that I got from the permit tech, that no permit was required. at that time so that they could go ahead and go into the unit to start the repairs on the subflooring.
So what happened after that?
I believe it was February 12th, as Mr. Robinson has said. I was notified that he was at the unit and putting another work stop order. So I was told to print out the email between me and Karen Hutchinson to show him with the reply of no permit needed.
Okay. And did you go to the unit and talk to Mr. Robinson?
Yes, ma'am.
Okay. And what happened?
Mr. Robinson was quite forceful with the fact that he had already put a work stop order on the unit, which I tried to explain to him that I'd only been in the position for 3 months, so I had no idea about that. But that I had emailed Karen Hutchinson about the permit, where he interrupted me and told me that she doesn't know what she's talking about, and if I ever have any questions about a permit, I was supposed to contact him directly.
Okay, and what happened after that?
He also saw the 2x4s on the wall, which I'm not a maintenance guy. I don't know what those were going to be used for, but he was like, he goes, and you're also framing out walls. He's like, there's 2x4s in there. And I said, absolutely not. I know for a fact you need a permit for framing walls, and that's not what was happening in that unit.
Okay, and was there anything else said by Mr. Robinson?
I think he took my wanting to just conversate about the issue as me being difficult, and he threatened to call the county, Brevard County Sheriff Department if I didn't want to stop the guys from working at that time.
Okay, and did the work stop that day?
Absolutely, absolutely. I told him that the work was going to stop. They weren't going to keep going, and I kept apologizing for the misunderstanding.
Okay. And since that day, have you been back to the unit?
I went back to the unit today to take some pictures of the subflooring.
Okay, and we have those photos with us today?
Yes, ma'am.
I'm going to present to the board and to council to submit into evidence copies of the photos we took today. And I think they're a little bit more clear than the photos that were presented by Mr. Robinson. I have one color copy, but then I have multiple in black and white. And I'm going to present the color copies to the ladies and gentlemen of the board.
Yes, please.
And we'll refer to one of the black and white ones, but I also have black and white copies. But I want you to be able to see the color copy because it kind of shows it a little bit better. And I'm going to wait for this to be handed out to the board before we discuss them. Okay. All right, Miss Lavoie, can you take a look through these photographs and tell me whether you recognize them?
Yes, I recognize these as the pictures I took earlier today.
Okay, we're going to start with the first page. Can you describe that first page for us?
This is a picture of me standing outside of the front door of the unit, looking in with the door open, taking a picture looking towards the back sliding glass door.
Okay, can you see anything in the floor that's been removed?
Yeah, I don't know.
I'm sorry, what was the question again?
Do you see anything in the floor in the picture that's been removed?
Yes, there's some subflooring missing there. I don't know exactly how big a piece.
Okay. All right, can you discuss on the second page, the photograph? And if you turn that sideways, it'll be a better view of the photograph. It's actually a sideways photo.
This photo is once you've walked into the unit, you're sitting in the little hallway foyer there. On the left-hand side is the same photo, the same piece of flooring that's missing from the first photo. And then there's a piece of flooring missing on the right-hand side of the living room. And then a small piece here at the bottom right-hand side of the page. It's right in front of the kitchen, a little flooring missing.
Can you go to the next page, please, and describe that?
Yes, ma'am. This is just, again, that piece of flooring that's missing in front of the kitchen.
Okay, and there's nothing, there's not floor removed from the kitchen, correct?
No, the entire floor in the kitchen is there.
Can you go to the next page, please?
Yes, this is a picture of me standing in the hallway looking into the bathroom where all of the subflooring is still in the bathroom, and it appears to me that at least half of the subflooring in the hallway is still there as well. And off to the right-hand side, you can see where the water heater is sitting. There's still subflooring sitting under that as well.
Okay, go to the next photo, please. Can you describe that? Which room is that?
This would be the first bedroom off of the bathroom. So this is me looking into the bedroom where there's some subfloor missing kind of around the perimeter.
Go to the next photo, please. Can you just please describe that as well?
This is the second bedroom. I would assume to be the main bedroom since it's got a sliding glass porch to it. Again, there's subfloor missing around the perimeter of it. It seems to be around about 50% of it.
Okay. And has anyone explained to you, do you have an understanding of when subflooring's done, that a permit's required?
No, I still don't know exactly if you need a permit for just repairs of a subfloor or if you need it at all times, no matter what you're doing to the subflooring. I still haven't gotten clarification on that.
Okay, thank you.
Can I ask a question?
They might want
Were any
You
of
have a
these,
question?
yeah, were any of these photographs shared with Karen Hutchinson when you were asking about the permit?
No, and had she asked me at any time, I would have been able to submit some to her. But no, she
So
didn't.
she didn't know what it looked like?
No, and I didn't know what it looked like either when I had initially asked the question myself.
I have a question also. Each one of these photos, you have said, here, subfloor is missing. It's not repaired, it's missing. It seems to me like you asked in your email, do you need a permit for repairing subfloors? We don't need to replace it, but yet each photo you mentioned subfloor is missing. How do you repair it if it's missing?
Especially if you're on the second floor.
Well, that is why I asked her in the email. The second sentence, I said, we don't need to replace it, we just need to repair some areas of it.
But you never said where we're talking about. If it's a house on a slab and you're on the ground floor, that's one thing, but on the second story, in a house that has wooden subfloors under it, it's a different ball of wax.
Karen, and I understand I had I had some, to give her as much information. I didn't have much myself,
No.
but I know that she didn't really ask me much either, and I'm not trying to put the blame on anybody here. I think that, you know, a question was asked and an answer was given, and in this instance, I went off, yeah, sorry.
Let me follow up. So had you been asked for more information, you would have freely given it, correct?
Absolutely. Me and Karen have gone back and forth before on some things.
But you couldn't have given her more information if he asked for it because you hadn't seen it.
Had she asked me though, I would have made sure that the property manager let me into the unit, or I would have asked the property manager for photos, which at that time they already had photos of the unit.
I believe Mr. Correa wanted to ask a question. Oh, are we done with?
Mr. Hartley, do you have
I'm
a
not-
question? I see one on your face.
No, it's just an observation, and it follows up with Mr. Hale, and the way this is worded, you say we need to replace it, and you say just repair some areas, but then I heard from Aaron, and I missed your last name, I'm sorry, that he replaced almost 50% of this flooring. In other words, he removed 50%.
I don't know if he testified he replaced 50% of the flooring. Maybe bring
Well,
up
I
Mr.
heard-
Aaron and you can ask him another question.
Well, I heard, and I believe you asked him, and he said almost 50%.
That's what it would have required to do the repair. That we're not, we weren't going to replace 100% the entire subfloor.
You were or weren't?
We're not.
But you were replacing 50% of it.
Less than 50% is what was required.
So this is not
That was
just-
my question of him.
My point is, this is not just a repair. We are replacing almost 50% of this floor. Correct? Correct?
Yeah.
Thank you.
But and this goes to my testimony, my argument regarding the notice that was to be a proper procedural process, we have to have fair notice and a fair opportunity to be heard. And part of that fair notice, that in the notice, it needs to be accurate. And Mr. Robinson did not state accurately in that notice. He stated that the entire subflooring was being replaced. But you saw from his photos, it was not the entire subfloor. On our testimony we just presented, the intent was never to repair the entire subfloor. And second, to have a fair opportunity to be heard must be in a meaningful time. And now I'm going to refer to Florida Statute 162.06, Enforcement Procedure. It says, it starts, except as provided in subsections 3 and 4, if a violation of the codes is found, the code inspector shall notify the violator and give him or her a reasonable time to correct the violation. In this case, that was 10 days. He wanted us to submit for a permit. Of course, our argument today is that we didn't need a permit. Should the violation continue beyond the time specified for the correction, this is the statute, the code inspector shall notify an enforcement board and request a hearing. That means after the 10 days expired, Mr. Robertson was required by statute, they must notify the enforcement board. That notification didn't happen until 6 months later. We did not receive an opportunity to be heard until now. We could have rectified this back in November or December, but now we're into May. So 6 months later, he notified us. And our argument, that's not a meaningful notice. Our argument is that he violated the statute. And that because of that, you know, this, just like the citation that was issued to Mr. Wells was rescinded, that this notice of violation should be rescinded as well. And I guess Mr. Correa has some questions to ask.
Good evening, members of the board.
To the mic.
I'm sorry. I have 3 or 4 questions for Mr. Robinson, if I may.
Are you done putting on your case?
Well, as part of the questions, and then she'll wrap up with an argument. Mr. Robinson, there was a citation issued in this matter, correct?
Yes, there was.
And can you tell me a little bit about that, please?
It was a contractor citation issued for doing work without a permit.
And to whom or to which entity was that issued?
If I recall, it was to Mr. Jeffrey Wells.
And that was subsequently dismissed, is that correct?
We voided it out.
And if you could explain the process of doing that and why that was done.
That's based upon attorney-client privileged information. That was based upon the advice of the city's attorney.
The dismissal of the
Yes.
citation?
Okay, that's all I have for Ms. Robbins.
Okay, I just wanted to bring to the attention of the board that, I'm gonna go through my facts. I'm not going to argue the case, I'm just gonna talk about some timeframes related to the case, which is regarding the rescission of the notice of violation. Yeah. Okay, so after the 10-day period that we didn't get the hearing, on October 17th is when we, Oceanside Treasurer, Wells Boys and Girls, Wells Boys, WBBC, which is the contractor, and Mr. Wells, we filed a suit against the city of Cape Canaveral and Mr. Robinson. That's pursuant to case number 2018 CA 049945. The construction contractor citation was rescinded on December 18th, 2018. That was 8 days after the court heard the city's motion to dismiss our complaint. The city gave us leave to amend our complaint. We filed an amended complaint on April 13th. 12 days later, on April 15th, is when we finally received our notice of hearing on the matter. And our reason why we're asking about the citation is the implication is that it was not a valid citation.
Say that last sentence again.
The reason why we're bringing up the rescission of the citation is that our argument is that it was not a valid citation to begin with.
Just let me clarify for this board. The contractor citation is not before you. I'm not really sure why they keep arguing that, but I think the point they're trying to make is the contractor citation has some kind of deficiency in it. I'm not sure how that relates to the notice of violation for this particular case, and maybe council can explain that. But I'm just trying to make it clear for the board that we're talking about two separate things.
Right, and the contractor citation was actually attached to the agenda, just to bring it to your awareness.
Yeah, that was, I
Yeah.
believe that was part of the original packet.
Right. And we're just raising that because this is all part of the sequence of events that has happened in this case. And apparently there's, just strike that. Let me look through my notes and see if there's anything further I'd like to say.
No.
I could ask Ms. Nutcher something.
To the mic.
If I could ask Ms. Nutcher a question?
I guess.
The attorney-client privilege, did he speak to the attorney directly about that, or was the...
That would be included in in the privilege. I can let the board know that there was a pending lawsuit.
And this is our
During
first
this-
knowledge of it.
Yes.
Right, because it would be, I didn't think it would be appropriate to be discussing that, but since council has brought it up, there has been a lawsuit pending for quite some time. And without going into legal strategy, there was legal strategy going on as to what should be done to resolve, for lack of a better word, the complaint that was filed. And we're talking about strategies that our office employed and worked with the city regarding. And a lot of the issues about the time was because there was this lawsuit pending. We had a motion to dismiss. We had to get a hearing date. We were successful. We got the complaint dismissed. They were allowed to amend it. And
We don't meet every month.
but that might help explain some of the time that has lapsed.
Yeah.
My question to the attorney is based on if he was instructed, he being Mr. Robinson, was instructed by, let's say, Mr. Dickey to dismiss it, or if he dismissed it on his own, that would not be attorney-client privileged. If he was told by you or your office that it should be dismissed, okay, that you have an argument.
I'm not going to raise an attorney-client privilege if the attorney didn't advise the client.
The client being the city, or the client being Mr. Robinson.
Obviously, the client is the city,
Okay. So,
but Mr. Robinson is an employee of the city.
I have a question, a procedural question. You have a lawsuit, we have an issue before this board. This board has to do with a factual issue having to do with this subflooring. Is the lawsuit dealing with the factual issue of this subflooring?
Yes.
Yes, it does.
It's safe to say that all of the arguments that they're making to you today are all of the arguments that they're making in their complaint.
Then I raise a procedural question concerning jurisdiction and which
I see what your struggle is, but it is appropriate to bring this before the board for the board to make its decision.
how does our decision relate to the lawsuit?
Well, one of the things they argued in the lawsuit is that the board hasn't heard the case yet. So,
I know.
so the board is now hearing the case and you make your decision and the lawsuit will still move forward.
Out there.
Thank you.
And on the same tack, decision that we make, is it an enforceable decision? Or is it going to be,
Well, it's an enforceable decision, yes.
okay?
I mean, they can do what they want with it. That's up to them to appeal it or however they want to handle that, but it is before you for a decision.
I just see a compilation of errors.
Yes.
And the first one was with lack of information with the request to get a permit. And it all has snowballed from there.
Well, perhaps we can hear, when council is finished, we can hear back from the code officer on that
Yes,
issue.
I would like to. Are you about through?
I just have one more point, is that Mr. AJ, he testified that he did not give Mr. Robinson a right to enter the apartment and take photographs, and that the information he gained from that is in violation, and it shouldn't be considered, and this notice and a violation should be dismissed.
In violation of what?
He trespassed. There's case law, I didn't bring it with me, but there's case law that the code enforcement officers need permission to enter their premises, and he did not have permission to enter.
Okay, that's a factual issue for the board to make a determination.
And if it's a life safety issue, he still cannot go in?
If it was a life safety issue, I think you should have issued the notice for the hearing immediately after the 10 days expired.
Excuse me, Counselor, you said fact issue, and I heard there's legal issues, so that's a legal issue concerning whether a code enforcement officer, based on the interpretation.
Oh, well, I meant the factual issue in terms of what Mr. Robinson said happened and what Mr. AJ said happened. Mr. Robinson, his facts were a little bit different than AJ's facts.
We can make a fact issue, but you raised a legal issue concerning whether he needed permission. That's a legal issue.
Whether there was consent and permission is a legal issue. Whether you decide who to believe in terms of what the facts were is your issue. And again, perhaps the building official or the code officer will address that further.
Where I sit,
I
those
could
issues
probably
go
help
hand in
clarify.
hand. The fact issue I can make, but the legal issue, as far as resolving that issue, it comes into play, is what I'm saying.
Before I sit down, I'm sorry, Chairperson.
Go ahead.
The memorandum, did we decide to admit that?
Well, it's not an admissible document.
Well,
If
I
you're
like it
you're
for the
presenting
record.
it, you can put it in the record.
Okay,
Yeah,
I would like to
sure.
put it in the record. Okay.
Can you pull up on the screen the pictures that you took, Chris?
Yes, ma'am. If I could, I got a lot in my head right here before
Sure.
I forget if I could address some of
Whatever.
these things.
Go, you suit yourself.
I'll go back to. Okay, I want to show you this photograph here to address the trespassing thing. This is from outside in the hallway, as you can tell by the door that's standing open.
That was a picture I wanted to see.
Okay. This would have been my view on my October 3rd visit when I had discussed with their witness here, can I see what's going on? So I had already seen that there's work going on right there. You now have already seen what had gone on based on the photos that they just presented to you tonight. So if we want to, we're playing a he said, she said thing here. So if we want to just go ahead and let's circumvent the he said, she said, you've got photos that they've provided with you of what the unit looks like and what I saw.
Yes.
This is what I saw standing in a legal position. I was legally allowed to be where I was at, where this photograph was taken here. Secondly, on this same date, I didn't take any photos because I'd already taken photos. Miss LeBoy walked in this residence with me and discussed with the two workers that were on site, discussing with me what these 2x4s were going to be used for, and we were standing in there, and I was invited in at that time and saw the same exact thing that you have seen in the current photographs and what I had seen on October 3rd. So we're going to sit here and play, oh, he didn't let me in. I'm saying I was allowed in. Okay, it's irrelevant now because we've seen the photographs that have been provided to you, and I was allowed in on on February 12th. But this right here, this photograph right here, was taken from a legal perspective. Okay. Also, I would like to touch on the email chain. If you look at that email, it was dated well after I had already posted a stop work order that was authorized by Mike German, the building official. So I'm hard pressed to believe, if you look at that, it's kind of, once again, a play on words. The fact that a stop work order had been posted on a piece of property when the question was posed to Karen Hutchinson, I think that's purposely left out. That's pertinent information when you're asking somebody, hey, does something that require a permit, when myself and the building official have already posted it with a stop work order telling them that it does require a permit. And now you're going to go talk to the permit technician who has no authority or no knowledge of construction to know what they're talking about when it comes to a subfloor. That's why she answered it back with flooring. And she has no authority to determine whether you can disagree with a stop work order that was posted by a code officer authorized by the building official.
I would like to ask a question about the permit technician. What is their job?
They issue permits.
Period.
Period. They issue permits.
Okay.
If there's a question about whether a permit is needed or not, that would go to Mr. German.
Exactly.
Period. He is the only one who is authorized to determine whether a permit is required.
But the permit tech has to have certain information before the permit's issued.
Sure. There's things that she's knowledgeable about. If somebody says, hey, do I need to put tile? Do I need to have a permit to put tile? Which that's what she thought that they were meaning. Well, of course, you don't need a permit. That's knowledge that she would know through doing the job and discussing with the building official. But subflooring, she has no clue what subflooring is. In fact, she said she has no clue what subflooring is. But the fact that they submitted this months after we had already put a stop work order on it, and they left out the fact that we put a stop work order on it, it's pretty telling, in my personal opinion. They knew that a stop work order was put. They knew that they needed a permit because I'd had conversations with them. So 105.1 is very clear. It states that any demolition, there's clear demolition there. Mr. German can attest to that. And they're repairing or replacing the floor. Now, it's another play on words when, yes, I did put entire floor, but I can only go by what I'm told by staff on what are you doing? We're working on the entire floor. So that's why I put entire. I have no idea what they're doing other than what I see and what I'm told. So that's all I can go by. I also want to touch on the due process that they bring up. I have chapter 162.06 in front of me where it's enforcement procedures. Nowhere in here does it say that, I can read it, the code inspector shall notify the enforcement board and request a hearing. It doesn't say immediately request a hearing. We gave them 10 days to get a permit. They didn't comply. There was some back and forth between me and other employees about, yeah, you need to get a permit. There was some disagreement, all of this. We gave them plenty of opportunity to get the permit. We were trying to work with them like we do, like this first case we had. We try to get voluntary compliance. We don't want to bring these things to you if we can get voluntary compliance. We weren't getting it. So I still didn't send a notice of hearing. Then I catch them doing the work again. The stop work order had been removed. They're doing work because of this email thing. And I put another stop work order. And this time we sent the notice of hearing to come before you because they disagreed that they don't need a permit. The building official can attest to the fact it does require a permit under section 105.1. It absolutely requires a permit. We've told them that several times. I don't know how they can disagree with it because he's the only one that has the authority to determine what needs a permit, what doesn't need a permit. Other municipalities may do things differently. This is the city of Cape Canaveral. This is what we require. The subflooring, per Michael German, the building official, does in fact require a permit.
It's our home turf.
Yes, ma'am.
Address one thing that Mr. Robinson was discussing, please. Okay, first, the picture he's showing you dated 2/12/19 with timestamp of 11/18:41 seconds. First of all, he was referencing what we're calling was trespassing illegally back in October of 2018. Then he's showing you this picture saying this is what I saw on that day, but he's already testified that those beams weren't there the first time. So that's just not true. There is no picture, or this picture is not of the day he went in unauthorized.
How do you suppose it got that time and stamp date?
I'm sorry?
How do you suppose it got that time and date stamp?
No, he went back. We're saying the initial entry, he trespassed and was not allowed entry, was told he couldn't come in, and he came in anyways. That was in October of 2018. The picture he's showing you here is 2/12/19. And on that picture, 2/12/19, I really don't see, he says that's what he saw. What in that picture says a permit's required for anything being done? Just 'cause there's wood sitting in there?
Sistering the floor joists.
I can see the floor joist there from sitting here.
Yeah, if I could
Absolutely.
address, I'm not saying that this is a representation of what I saw on October 3rd. What I'm saying is, I can see the violation. I can see the floor joist. I didn't say anything about the 2x4s being there. Said this is a representation that I can see unpermitted work was being performed on October 3rd from a legally allowed position.
That's not repair, that's being replaced.
I mean, that could look like a crate sitting on the floor.
No,
No.
Can't tell. from
that's
there.
floor joist.
Okay, well, that's our argument based on that picture, which doesn't.
Looks like about a half a sheet of plywood's been
accurately
removed.
reflect.
Okay, where do we go from here?
Do you have a recommendation?
Yes, I sure do.
Wait a minute, Charlie.
Is there
you gotta-
anything further the council needs to present?
I just want to clarify that, Mr. Robinson did not send the notice out after this, February 12th. The notice was sent on April 15th after our amended complaint. I'm sorry. Mr. Robinson just said because of this, he sent out the notice of hearing. The notice of hearing was not sent out, this is February 12th, it was not sent out until April 15th. And that was like 10 or 12 days after we filed our amended complaint, which is when actually it was raising the issue that there was a long delay in receiving our hearing. And I also want to address the statute. And he said, oh, it doesn't say anywhere. It says, should the violation continue beyond the time specified for correction, the code inspector shall notify. Shall. In legal interpretation, that means he must do it. It says, should the violation continue beyond the time specified for correction? His time specified correction was 10 days. And after that time, if this was such an immediate safety concern, he would have issued the notice of violation in a timely manner, and we would have a meaningful and timely opportunity to be heard, and we have not had that. Even though this hearing's taking place today, it did not occur in a timely manner. Thank you.
Would it make a difference as to whether or not there's going to be a correct and proper and legal repair?
Well, we would hope we would get direction from the board a lot sooner than 6 months later. And it's been our contention all along that looking in through this doorway, all you see is that the carpeting, the flooring, Carpeting was removed, and there may have been one 4x8 that was removed of subflooring. You don't get, he's sitting here saying, well, legally, I'm looking in and this is what I see. Is this the entire subflooring? You notice it didn't say entire floor.
And again, my
doesn't
question
say
is
entire
it gonna matter when you get around to fixing it legally and properly and correctly?
Well, as far as we're concerned, that this notice is illegal. I don't want to admit to that, because as far as we're concerned, this notice is illegal and it's a violation of our due process rights.
And again, when will the repair be done? Whether or not it starts tomorrow?
We would have gotten it done had we not got the stop work order, because it was our position that we did not need a permit to begin with.
Oh,
I have a question for the building official. Looking at the picture of 21219, is a permit required?
That would lead me to believe that, yes, it would, considering what I'd heard from the testimony.
Thank you.
The other thing, you said based on what you heard, but not the picture alone. That's the testimony. The picture alone. Nothing else. If you just saw that picture,
Could you go up to the microphone, please?
if you only saw that picture, Mr. German, can you definitively deduce that a permit is required in there?
At that point, I would recommend a stop work be placed and be granted entry to do my investigation.
So you would require further research or to investigate before you could actually determine if a permit was required?
That is correct.
Thank you.
I have a question for him. And looking at that photo, do you see floor joists?
Yes, I can.
Thank you.
And what are you maintaining?
Microphone.
I'm sorry. What are you maintaining are the floor joists, Mr. German?
the two you can see
Am I
in the
maintaining that those
picture.
are floor joists? Yes, they are floor joists.
The leaning against the wall?
No.
In the floor.
Oh, on the floor?
In the floor.
Okay.
Floor joists are generally on the floor.
Right. Well, I thought you were talking those would be replacements. I thought that's what you meant.
We weren't replacing floor joists.
Okay. I thought I was misunderstood that. Yeah.
Okay, Mr. Robinson.
Based on the testimony and evidence submitted at the hearing, staff respectfully requests that the Code Enforcement Board find the respondents in violation as set forth in the notice of violation and give the respondents until June 7th, 2019 to come into compliance or fine be imposed in the amount of $250 for the first day and $100 every day thereafter until compliance is confirmed by the Code Enforcement Officer and all costs associated with the enforcement of the violation be imposed.
Three weeks? 2.5 weeks?
Looks like.
Please don't make me do math.
Compliance is just getting the permit, right? So that's just the one act. It's not a-
You have to keep speaking into the mic.
The compliance is just getting the permit, correct, Mr. Robinson? Is that what you're asking?
All we are requesting for is they obtain a permit at this time.
I would like to ask a question of Ms. LaVoy before I make Ms. LaVoy, based off of your experience of working with the city of Cape Canaveral, can you obtain a permit in 2.5 weeks?
I've only been able to obtain one permit within that amount of time. Usually it takes about 3 to 4 weeks to get a permit approved. And may I add, that's with having every bit of evidence that they need, any photos, product approval form sheets, subcontractors and everything.
Actually, I'm copied on all the emails that go back and forth, and I know that proper documentation is generally not submitted. And she eventually does get it to us, but it does take some back and forth.
Mr. German, how much time would you estimate? Would it be a reasonable time?
Generally, we turn around in 2 weeks, but if we got to continuously go back and forth with trying to get documentation, it takes longer, obviously. I mean, we have to get what's required by code to be able
What'd you
to make
say,
a
Charlie,
permit.
the 12th?
4 weeks, something, 12?
Today's the 23rd one. The 20th, which would be our next meeting date. How about the day before our next meeting date, the 19th of June? Does that work? Does that give you enough time, ladies?
Yes, ma'am.
That's all right with you, Mr.?
Yes, ma'am, I can have it into the city tomorrow.
And how about you, sir?
Yeah, that's fine, yeah. And Ms. LeBoy, I'll be out until Wednesday of next week. If you will bring it in and ask that I look at it, I will move that to the front, and I will get with you and make sure that I get exactly what I need for that permit.
So we have a motion. Do we have a second?
Did you make a
Oh,
motion?
no, that was an out loud
I am
thought,
not-
right?
What, the date again is
The
the 20?
19th of June.
19th. I move we accept staff recommendation by striking June 7th, 2019, and inserting June 19th, 2019.
Yeah, I'll second that.
There we go. Any other questions or comments? Ladies, you're awful quiet down there.
They're thinking about it.
They're thinking hard. If there are no questions or comments, then we'll call a vote.
Ms. Russell?
4.
Mr. Hale?
Or,
Mr. Hartley?
4.
Ms. Collins?
4.
Ms. Stone?
4.
Okey-doke. You heard his dates that he needs you to have everything ready for him by.
Yes, sir, thank you. Yes.
Thank you. All righty, we got one more discussion tonight. Let's see, this is a sign on A1A. Oh, my goodness. We have a different gentleman at the mic.
Okay, I'm sorry, mine's gonna be extremely drawn out and long. Just kidding. Okay, the address is 8699 Astronaut Boulevard. The violation is for non-conforming sign. It falls under section 94-121, subsection D, non-conforming signs. I've placed the code on the board,
I've got one. You want it
the
back?
city code on the board. I will paraphrase the city code. The city council, I don't recall, what was it back in, okay, September of 2014. They decided to terminate all pole signs in the city. I've brought this to you in the past, another case in the past. So we are now in 2019, and we are attempting to bring everyone into compliance, and we have been very successful on a lot of them. So that's where we're at today. The notice of violation was sent on 10/11/2018 with a return receipt of 10/19/2018 to, I'm not going to butcher this man's name, Logis Karakos. The notice of hearing was sent on 5/8/2019 and a return receipt of 5/16/2019. This is the property in question. Everybody knows it as the Subway or the Kelsey's.
oh,
On 12/2/2015, a letter was sent to the property owner. This was a letter that was sent to all property owners that had a pole sign informing them of the city council's decision to eliminate them. On 2/15/2018, a second letter was sent out stating that if you didn't start doing something soon, we were going to start sending notices. On 10/10/2018, a notice of violation was sent to the property owner. On 12/6/2018, the owner contacted staff stating the sign company is charging him $9,500 to bring the sign into compliance. Property owner stated he believed this was too much due to the fact there was nothing wrong with his sign. Staff informed the owner he needed to speak with the building official and transferred him to the building official's extension. The building official attempted to contact the property owner on 2 separate occasions, on December 6th and April 18th. On April 18th. On 5/8/2019, a notice of hearing was sent to the property owner. On 5/22/2019, the property owner contacted staff and stated the sign company would be applying for a permit in the next couple of days. This is the sign in question. As you can tell, it is a pole sign, per the definition of a pole sign. I think that's in my notice that you all
We see the one
received.
across the street.
that's what I
the
was
same-
thinking.
That has a permit. That has a
It's already
permit has been,
permitted to be done?
a permit has been issued for that sign. That's another one of mine. You're welcome. The property representative is not here today. He came in earlier. We discussed this. He told me he was going to turn in the application and everything. Asked if he really needed to be here. I said it's your choice if you want to be here or not. I informed him what I was going to ask the board to give him. He was fine with that, so he decided not to be here present. Can I go with my recommendation?
You may.
Based on the testimony and evidence submitted at this hearing, staff respectfully requests that the Code Enforcement Board find the respondent in violation of Section 94-121 subsection D, nonconforming signs of City Code. Give the respondent until June 20th, 2019 to submit an application for a sign permit to the building department, or a fine in the amount of $100 for the first day and $75 every day thereafter until compliance is confirmed by the Code Enforcement Officer and all costs associated with the enforcement of the violation be imposed. I'd like to explain my recommendation real quick. I've been working hand in hand with the building official on all these signs to try to get them corrected throughout our city. And we've come to, find that the signs, not only can you just submit a permit, but you also have to have engineering on these signs. So it takes a little bit of time to, once they submit the permit, for it to go through the plans examiner, it goes through the building official. We all discuss it. I think all three of us have discussed every single sign in the city that we've been replacing. So it takes a little bit of time to get a permit issued. That's why I'm not saying issue the permit by this time. I'm saying that I want him to submit the application by this time. If he doesn't submit the application, we'll go down that road. If he does, then we'll give him time for us to review the permit and to issue the permit. And then, of course, after that, you have 6 months. I'm sorry. After that, you have 6 months. The permit's good for 6 months as long as all the inspections are going.
As long as we don't have another big storm between now and 6 months, he might get his.
No, we're good.
El Nino's coming. Take care of us.
The weatherman said we're okay.
Yeah.
Anybody want to make a motion regarding this recommendation?
I'll make a motion to accept the staff's recommendation.
I'll second it. Any further discussion? All vote?
Ms. Russell?
For?
Mr. Hale?
Or,
Mr. Hartley?
4.
Ms. Collins?
4.
Ms. Stone?
4.
Sorry that took so long.
I'm going to charge you by the minute.
one moment, madam.
Oh, yes, sir?
I understand you had a video, you watched the video of the city council
Last
Tuesday
night,
night.
I did.
Is there anything of interest to this board that you saw?
Other than my comments about talking into the mic. Yeah, we were complimented right highly as
Okay.
as the work that the board does. I think the problem is that, again, as Mr. Campbell is concerned, the length of time of achieving compliance is something that's hard on everybody. But all in all, I was pleased with what we heard. What were you referencing, Mr. Quiet Person next to me?
What you just said.
Okay.
Because somewhere in here I saw something where of all the city boards, we were deemed lowest rating.
I don't think it was the board itself that was deemed the lowest rated. It had to do with what happens with the orders that come from this board and the amount of time it takes. And of course, there were more than a few thousand references to the fact that we're operating with 2 code enforcement officers when we probably need 4.5 right now. Mr. Dickey, you look like you moved to the mic to say something.
Yeah.
Yeah, I mean, it was certainly an interesting conversation, but I think in response to Mr. Hale's question, I think it was I'll say the negative comments were focused at the city code enforcement staff, frankly.
Oh,
Yeah. And they operate shorthanded.
yeah. Okay.
I don't think there were any comments directed at the board per se.
No, I think it was very complimentary discussion about the board.
I would just comment, I sent an email out, as you've seen, and I was trying to be as objective as I possibly could.
Yes, you were.
And there was objective information in there that I was supplying, so I did not wish to voice an opinion, but I am pleased to serve on this board, and I have great respect for all of its members.
And we have a member in the audience who said she wouldn't sit on this board for anything.
Yeah.
Ms. Raymond
And-
was in the back.
And let me say
She
this.
didn't want to be up here with us.
Let me say this, I also, I have done, of course, investigative work, and I appreciate the work that staff does. It's a hard job, and you're out there on the front line, okay? And we're getting the benefit of your recommendations, and you're doing a good job, in my opinion. So, thank you.
They catch the slings and arrows, and we get the thank yous.
Right.
Yeah, thank you for that, and I appreciate those words, because it is, I think Brian and Chris probably have the most difficult jobs in the entire city.
Right.
I tell them that all the time. It's a very fine line you walk, because as you know, and I'm sure you heard around the community, code enforcement doesn't do enough for some people, and we do too much for other folks, or we're too effective, I guess. And you know, when you know, a perfect example is this evening. I mean, we've got, I don't know how many lawsuits currently we have against our code enforcement function in the city, 8, 10, something like that. So, you know, I'll just say this, and the reason those lawsuits are there is because they, you know, we're getting after it. I think we're taking care of business. And it's a really fine line, and but again, thank you for those words. It's much appreciated.
I think we should cut the mics off.
Yep.